News 24 senior legal reporter Karyn Maughan. Karyn, thank you for being with us. Firstly, do we know that the big question is now, does the former president need to hand himself over or not? Is there a stay or not?
Well, essentially, an argument may be advanced by the inquiry when they file court papers in the Pietermaritzburg High Court tomorrow that should he not hand himself over, he will again be guilty of contempt. But unlike in previous circumstances, I think that there would be a valid defense that he could offer. He has approached the Constitutional Court. The court has issued directives saying it will hear his case for a rescission. And he has also gone to the High Court in Pietermaritzburg to seek a stay of the committal orders granted against him by Justice Sisi Kampepe on behalf of the entire court. The police have 3 days after Sunday in order to make sure that he's arrested and then committed to a correctional services facility. So the timeline of his urgent application falls within that 3 days. Where things may or may not get sticky, Francis, is if the courts take longer than Wednesday to reach a decision, and then obviously I think the police and the parties in this case will have to seek guidance, or if the court straight up says, well, I don't think you have prospects of success in this case and refuses the stay, then obviously the cards shift.
Yeah.
But my understanding is that there is an undertaking at this point from the police who have been served with Jacob Zuma's interdict, that because it falls within the time period for them to also not be defying a court order by not arresting him, they will, play and see what happens play it out and see what happens with the court case. But I think there may be an argument that says if he doesn't hand himself much over tomorrow, he is again in contempt of court. But I think his argument would be, I have a valid defense. I believe the court has got it wrong. I've addressed my legal options. I've lodged a court case that the Constitutional Court has agreed to hear, and I've sought an interdict, which are all my appropriate legal remedies. So he has got a defense against a contempt accusation in that particular situation, I think.
Okay, so let's just outline what you're saying is likely to happen, that he probably won't hand himself over tomorrow. Police then probably won't arrest him because they have until Wednesday to arrest him. But on Tuesday,
Correct.
He will be in court saying, stay my arrest. So it could become legal then if the court agrees.
Absolutely. He can't. The Constitutional Court agreeing to hear the case is a victory for him, undoubtedly, because there has been a previous rescission matter before the High Court involving the Tlhophe Tribunal and Justices Best and Kabinde and Chris Jafta, where they failed to have a certain ruling decision made by the Constitutional Court in relation to an appeal that they had brought in connection with the Tlhophe matter. It was dismissed by the court, which provided reasons without hearing the case. They then sought the rescission and failed. So there is a form of legal precedent for this. But the fact that the courts agreed to hear this case puts Zuma in a far better position in terms of getting that urgent stay. Because he can turn to the High Court and say, listen, this matter is being heard on the 12th. I fundamentally believe that this prison sentence is a death sentence. I'm a 17-year-old man. I have chronic medical conditions. And I believe that, I'm arguing for a rescission or for a reconsideration of my sentence. And the kind of prejudice I will suffer if I'm jailed, and the court, for example, maybe makes a different decision to what it has, will be immense. And in circumstances where the Constitutional Court hasn't outrightly dismissed this rescission application, has now issued directives, says it will hear it, he's in a far better position to make an argument for a stay than he would have been if the Constitutional Court had not made a decision or had just simply dismissed the case. Then he would, obviously be in a great deal of legal difficulty.
Yeah, however, he is asking the very same people who made a decision to now change their mind, and he had opportunities, it might be argued, to make any sort of argument he wanted to when they gave him that chance.
Well, absolutely. And that is at the heart of this case, is that, the Constitutional Court issued directives 2 weeks after hearing the contempt case, which he chose not to participate in, saying, what sanction do you believe would be appropriate? And Jacob Zuma, instead of taking that opportunity, as Justice Sisi Kampepe said in the majority ruling, squandered it. Wrote a letter to Chief Justice Mogoeng, in which he said, quote unquote, that he was willing to be a prisoner of the Constitutional Court, and then used the opportunity to attack, amongst other people, Acting Justice Daya Pillay, who he said shouldn't have been on the bench against him because she'd ruled against, obviously issued an arrest warrant for him when he didn't show up for his corruption case because of health issues. And then which was later, which she suspended, and then ruled against him in the defamation matter involving Derek Hanakor.
Yeah.
He used that opportunity not to make an argument, as he now is, saying, I'm 79 years old, I have chronic medical conditions, this is a death sentence for me, please reconsider, let me call medical experts. He didn't use that opportunity at all. And I expect when the inquiry files its papers on Tuesday, articulating its response to his rescission application, that it will raise that exact point.
All right, let's see how this plays out. We'll bring you some more legal analysis shortly. That was News 24 senior legal reporter Karyn Maughan. Thank you so much for your time tonight. Meanwhile,